an additional statute that addresses whether or not deadly force can be used. It does reference what Pastor Stewart just read, but it goes on to say that you can only use deadly force in that regard if there's an imminent threat of death or serious physical injury. So to be able to use deadly force, it's another step up on the circumstances that have to be presented. But with the scenario you just read, you're right, it fits within that statute.
Yes. All right, so a question I have here with that is, do you as a county attorney believe that this law needs to be adjusted, changed, revisited? Because it seems that this particular law is failing the community and it's failing the officers.
I think, and this is where we've got some serious work that we need to do, because there's a training component, and then there also is a component from us as citizens in our interactions with law enforcement. And let me share what I mean. Overlaying all of this is a Supreme Court case called Gray from 1989 that talked about how you look at an officer's use of force, and that you have to use an objective standard about what would a reasonable police officer have used in that circumstance based on the facts that the officer knew at that time. Well, if a police officer comes into a situation where they're answering a call and they're told that there are two suspects, one has a weapon, and the calls come in from somebody who observed them, say, outside of the house, and law enforcement shows up, and the two people who are out in front match the description. Maybe the description is something no more specific than white shirt, blue jeans. And maybe the person out front's not really wearing blue jeans. Maybe one of them is really wearing blue khakis. But that's the information that the police officer has when he gets there. And he's talking to the two people. And the two people won't say anything to him. Now, I have a Fifth Amendment right to not say anything. But in not communicating, the officer's understanding when he got there that one of these two people may have a weapon is the only information he has to be able to act on unless and until he gets something different. Maybe the two people who were originally reported have left, and these are two completely different. And they have no idea why the police officer is rolling up and why he's even talking to them. Right. And then they look at that officer, hey, I just got here. I don't know what your problem is. Well, he doesn't know what the problem is because they've yet to communicate. What I'm suggesting is that answering a police officer's questions, following their directions until it's a point where the person being talked to understands why the officer is there, and the officer understands I don't have a threat in front of me. Until that happens, the police officer is going to assume I've got a threat here. Is that assumption valid? Well, this is where it's hard too. In the last few weeks, we've had a couple of officer-involved shootings where the first thing the suspect did when the police got there was to shoot. And the officer had no reason to think that there was going to be the immediate use of deadly force, and then they had to respond. And there are other times where the police officer can show up and be able to find out talking to somebody that the situation is not as it was initially reported, or the person they're talking to is not the person they need to go find, which is a good thing because they don't need their time taken up by somebody who's not a threat to anyone and be able to move on and find out where that threat is. Now, what's the other side of that? The other side of that is continuing to train police officers and to keep them aware of what that perception is in the community, so that they do get cooperation, but so that even though they have to keep officer safety at the forefront of their mind, that they're also sensitive to the fact that I need to confirm or deny information. Until I do that, depending on the circumstances, I need to keep this as low-key as possible. There's room on both of the sides of that equation where we can find a better middle ground. I think we need to continue to focus on training. I think the law that we have in place tries to strike a balance, because every single one of these cases is so fact intensive. How is a person presenting himself? What does the officer know when he gets there? What's their tone of voice? I mean, if you're not a threat to the police, first thing out of your mouth, a series of invectives or cursing. For all we know, maybe that person has Tourette's. Maybe that person has a mental illness. So being able to train for a differentiated response can be key. But if the person who's cursing doesn't have any of those issues, they're not helping the police officer assess whether or not they have a dangerous situation. And fundamentally, what's the biggest issue that we've got between individuals often, whether it's at home, at work, or this scenario? Poor communication. So I would say that the law itself as it is, it follows U.S. Supreme Court guidance, but we've got a whole lot of room where we can work on involving training and communication, community understanding,